Hello, everyone. Thank you, James, for setting us up. And hello, OrcaCon. I heard in the last panel that there were some concerns that this was going to be a boring panel, a boring workshop. And it is the law. So, of course, those concerns are valid. But I'm going to try to make it as exciting as possible. My name is Ethan Vodde. I am an attorney at Lee and Hayes. We are a law firm that focuses on intellectual property. The lion's share of our attorneys are patent attorneys. I work in the trademark and brand protection and copyright practices. And I'm super excited today to talk about copyrights, trademarks, and games because we're going to talk about rights. And I think that knowledge of rights is something that everyone should have. So in terms of the audience for this particular presentation, I'm hoping that yes, some game designers get something out of the presentation, but I'm also hoping that game players get something out of the presentation, and that artists and anyone involved in our games industry gets something. Because when we talk about intellectual property rights, we talk about knowledge of rights, and everyone should understand, at least have a basic understanding of rights. So I'm going to start sharing a screen here. Minor disclaimer before we start. Thank you, OrcaCon, for allowing me to give this presentation. I have no association with OrcaCon. Lee and Hayes does not represent OrcaCon. I do not represent OrcaCon. I am a panelist, and I'm stoked to be here to talk about this. So let's share a PowerPoint. You know how some people share PowerPoints, they just read off the screen? I'm going to do my best not to read off the screen. Let's talk a little bit right here. Here's the title. There's me. There is our the name of my firm and a nice little logo right there. Lee and Hayes is this presentation is cribbed a bit from one of my partner's presentations. So you'll see some slides that have really cool animations and some that don't. These are the offices that my firm has across the United States. I guess this is indicative of leadership's desire for me never to attend an Adepticon. But that's where we're located. I'm over there in Spokane, Washington, not too far away from where OrcaCon would be if we were actually doing this physically. And I really hope to attend next year when we are physical, right? Hopes. Disclaimer, this is a slide I am going to read because I am attorney, and we have to say stuff like this. These materials and the related presentation are for informational purposes only and not for the purpose of providing any legal advice. They relate to the US only and are not necessarily indicative of information relevant to other jurisdictions. You should contact an attorney to obtain advice with respect to any particular situation. You all probably hear this a lot when you deal with lawyers. If you deal with lawyers, I'm not giving you any legal advice. And there are a few reasons. I don't know why we don't just tell everybody why we do that. One is the obvious reasons, is that lawyers don't like to work for free. But there are some ethical reasons why this could happen too. My firm represents rights holders. And those are relationships that we currently have in an attorney-client relationship. We zealously defend these rights. If I were to give advice, legal advice, to someone concerning rights, and it turned out that that advice was opposite or detrimental to one of my clients, there are ethical implications there. So one of the reasons why I won't be answering any specific questions or analyzing any specific legal issues, one of the reasons, of course, you know, there are other reasons, but one of the reasons is that I'm ethically obligated to represent my current clients to the best of my ability. So when you engage a lawyer, this is why there's that whole conflict check period. Well, hold on, let's run conflicts, make sure that my representation of you won't conflict with anyone else, etc. It's not that I don't want to. I do. I care about your issues. It's just I care about everybody's issues, right? Or at least particularly my clients. Here's an introduction of overview of what we're going to talk about today in terms of intellectual property rights. I know I said it's going to be about trademarks and copyrights and games. If we have time, I'm looking at the time right now, that I might address a little bit of patent rights. Some folks are going to be like, well, I got a great idea about a mechanic in a game or a function in a game. And those kind of ideas really fall in the patent realm. So hopefully I'll talk a little bit, but right now, like I said, my focus is talking to developers, to designers, to artists, and to players. And specifically as relates to virtual tabletop participation and streaming participation, and understanding, or at least an acknowledgement of the rights that go behind these kind of venues. So I want to focus on trademarks and copyright specifically. So I'm going to break it down 3 parts. What is the right? How is the right protected and how is the right infringed? Hopefully this will give us a better understanding, and we as gamers can start to look at things like terms of use, because you all read those all the time, right? Every single word. They're actually fun, and as gamers, I hope to bring you a new appreciation to these terms of use and terms of service that you might read. So let's focus in right now. Intellectual property, what is the big deal? Why isn't information free? Why did our founding fathers decide when they wrote the Constitution to include copyrights and patents in the Constitution, even though it took them a few years to talk about, freedom of speech and a couple hundred to talk about what to do in further amendments? But from the very get-go, we knew that IP was a big deal. And the reason why IP is a big deal, the reason why our founding fathers were willing to grant a limited monopoly, and why we still grant a limited monopoly or a monopoly for limited times to certain intellectual property rights, is because we are an information-based society. And we are a knowledge-based society, and intellectual properties can assist the entirety of society. Here's the idea, is if we give a limited monopoly to an artist, to an inventor, to a participant in the useful arts or the sciences, then when that monopoly is over, the entire public gets it. And that particular individual, that particular author that created that work can then move on to create other works. And we can kind of keep this in a perpetual motion so that we can continue to enjoy this knowledge and this art. Here is a slide that was imported from another of my partners. Check this out. Here's the S&P 500, where in 1975, tangibles represented about 83% of market value. But we move into today's time, and intangibles have the lion's share. That's 90% of market value for our S&P 500 companies. What does this mean? This means that IP is incredibly valuable, and because of its value, it is going to be enforced. The big players in the game care about their IP, and it then behooves us to understand what rights that we have when interacting with these big players, or when creating our own IP, or entering into the market, how those rights can interact, how we can protect them, how we can risk infringement, how we can mitigate that risk. So there are four basic buckets of IP. I know I said patent, trademarks, and copyrights, but there's trade secrets too. Patents cover inventions and designs. Trademarks, any name, symbol, or device that's associated with a good or service. This is our consumer protection intellectual property right. And then copyrights, the literary and artistic works enshrined in the Constitution, and folks all, at least in the gaming industry, have some concept that copyrights do exist. We're going to talk a little bit about what those copyrights are. Finally, we're not going to cover today trade secret law. Trade secret is if you keep it secret and you derive economic value from keeping it secret, you can have rights. A party can have rights in that particular secret. Those are the two basic ideas. And if a party is to misappropriate that secret and then take it outside of that kind of shrine that the party keeping it secret is holding it, then that can be actionable. That's a trade secret right. Not really gonna touch on that. Today's focus are trademark and copyrights. Here's patents. I'm gonna skip this over. If we have time, I'm gonna come back to it because I want to make sure that we talk about trademark rights and copyrights in the limited time we have. All right. Are we bored? A little bit. Let's get exciting. Trademarks. Trademarks are based on an idea of consumer protection. The idea behind granting a trademark right is that the consumers out there are accustomed to seeing a particular name, symbol, or device associated with a good or service. And when they see that name, symbol, or device associated with that good or service, they ascribe a certain amount of goodwill to that good or service. There's a trust that's involved there from the consumer perspective. So in order to maintain that consumer trust, in order to protect the consumer from being confused or from being deceived or from not understanding the good they're getting, trademark rights are granted. The idea behind it is in any particular good or service, if there's a name, symbol, or device that is consistently and continuously used that in connection with the sale of that good or service, that is distinctive, that is to say, it's inherently distinctive, or it's acquired distinctive, or it has acquired distinctiveness. It's not generic, and it's not merely descriptive of the underlying goods and services. For instance, you will never see a trademark for beer that is beer. Or a trademark for toys that is just toys. And it must not be the same or confusingly similar to another trademark already in the market that's used on the same or similar goods and services. It has to be non-functional. This isn't your mechanic or your process. If we can have time to get back to patents, we can talk about how the functionality of a patent and how that can be protected. But the protection that's afforded with this trademark, everybody knows trademarks. Everybody knows your brands. I love my brands, and my brands, when I see them, I know there's a certain amount of goodwill that comes with those brands. In the gaming industry, I could name a number of brands that are either incredibly well known or are maybe lesser well known. But every single one of those is going to have some sort of thing in the back of my head as a consumer that says, I know what I'm getting there. If there's protection that's granted for a trademark, that protection is granted against any sort of likelihood of consumer confusion. So another party can't jump into the market with that same trademark and say, hey, look, it's us. And then consumers say, oh, it's those guys. We don't want consumers to be confused from the party that has priority in its mark ownership. The idea behind that is well, consumer protection. Everybody, I think, understands this idea. The thing that some folks don't understand is the mark, although it's owned by that particular entity that's using the mark in commerce, that's using the mark in connection with the sale of goods or services, the protection isn't there because we want to defend the company. The protection is there because we as society want to defend consumers and make sure consumers are not confused. And for that reason, that trademark can last forever, so long as that trademark maintains its distinctiveness, and if it's a registered mark, it's periodically renewed. Let's talk about that just for a second. How much, Ethan, does a trademark cost? And the answer is, well, it's free. Absolutely. Of course it's free. We care about protecting consumers. And because we care about protecting consumers, as soon as any particular individual source starts using a mark in commerce, then trademark rights are automatically going to start being gained. That is the instant that trademark rights start being gathered. However, there is, of course, there can be costs associated with it. This is a screenshot from the United States Patent and Trademark Office. The United States Patent and Trademark Office is the place where you go to register your trademarks. Man, I've got some great hand motions here, and I don't know if you all are actually picking up on this or not. It would be nice, but whatever. Maybe we can. I'm going to stop sharing for just a moment so I can give you my hand motions. Okay, here are the hand motions. The United States Patent and Trademark Office is the place to go to register a trademark. Registration of a trademark does cost money. The USPTO charges a filing fee, anywhere between $250 and $350 per class that you register the mark in. But there are certain benefits to having a registered trademark. As I showed you right here, these are live and registered trademarks having to do with role-playing games that have been registered since 1800. There are, before the USPTO, 2,978 registered marks. These are trademarks that have gone through the application process, have been approved for registration by an examining attorney, have been moved into a notice of publication, have been published in the official gazette, and now enjoy registration. All that's a bunch of boring legal nonsense to say that, hey, the United States recognizes that over the entire country, these trademarks have priority and rights associated with a particular good or service. The presumptions that come with, I don't want to stop sharing here. Hold on, having technical issues. The presumptions that, am I still here? All right. The presumptions that are associated with, oh, there we go. Stop share. The presumptions associated with a particular registration of a trademark are really, really handy. Here's the reason why you register a trademark. And the reason is because of, why are my technical difficulties so difficult, I ask you? The reason is because the presumptions afforded a trademark in order to show infringement of a particular trademark. James is trying to help. I appreciate that, James. Let's keep in mind that I'm a lawyer and not a streamer, although I will talk about streaming a little bit. I don't always know what I'm talking about for when it comes to how to do it. I can protect you just fine, but when it comes to how to do it, don't really know. All right, let's share this screen and then get back onto this one right here. Okay. All right. We were talking about presumptions of registration of a trademark. In order to show infringement, a plaintiff has to show that they own a valid trademark, that the defendant's use is not authorized, and there's a likelihood that consumers are going to be confused. This is how a trademark gets enforced. And that ownership of a valid trademark is kind of a big deal. And registration on the principal register through an application process to the USPTO will actually will serve as prima facie, as there's a presumption that the owner owns a valid trademark. So you can kind of skip all that. You also get a couple of other good deals along with it. But hey, have you ever gotten a cease and desist letter concerning a registered trademark? A company sends, it's a company you like, a company that you are a fan of has sent you a letter asking you, or demanding rather, that you cease and desist that particular use. Really, this is something that we as an industry struggle with, because a trademark has to maintain its distinctiveness. It has to maintain some sort of connection to those goods and services. And there are ways that that trademark can actually lose that distinctiveness. One of those ways is through something that we call genericide. This is a tin of Bayer's aspirin. Everyone knows what aspirin is, right? Aspirin was a trademark for a particular good that Bayer imported into the United States and helped people with their headaches. But everybody started calling this good, no matter whether it came from Bayer or somewhere else, aspirin. In doing so, that trademark lost its distinctiveness. It suffered from what we call genericide. It became just a generic name. So whenever a trademark owner has to try and even though it's suffering from popularity, even though it's suffering from everybody calling the thing that it does or the goods that it has by its particular trademark, it needs to ensure that that trademark maintains its distinctiveness, that consumers don't just think of that mark as the generic name for a particular good or services, good or service. The same way, we also need to make sure that there is some quality control behind it. If everybody were to use that trademark for whatever good and service they want, and there was never enforcement from the trademark owner, consumers would stop having that same goodwill associate with that trademark. That's why sometimes fans get cease and desist letters. Trademark owners have to ensure that their trademark maintains that level of distinctiveness, which can be a little bit sad. Because people get upset, and owners don't like doing this either. They don't like saying, "Hey, fan, stop using this thing that is my that's indicative of the source of my goods or service. Even though you're an amazing fan, I might have to sue you." Trademark owners have to enforce their marks in order to maintain that distinctiveness, and that's just that's the reality of the law there. Of course, it's not as simple as that. There are nuances, but I wouldn't be much of a, where is it? Man, it is difficult for me to find this thing right here. There we go. I'm going to make more hand motions, so I have to find the stop share, because we're going to move on now to copyrights. This is probably something everyone is excited about. I've heard a lot of discussion. There's that common myth that, hey, if I'm not selling anything, then I am free to use it, and it's just not always the case. But let's talk a little bit about copyrights. Copyrights are any original work of authorship fixed in a tangible medium of expression. How about that? That's when a copyright exists. Any author that puts down this independent original creation, that is, that author comes up with it, even if it already exists, that author just comes up with it independently, that has a minimum amount of creativity and is non-functional, then fixes it in a tangible medium expression, copyright instantly occurs. How much do copyrights cost? Hey, just like trademarks, they are free. The idea is that when that author fixes it in a tangible medium expression, at least in the US, now copyright exists, and you can use the encircled C. Those copyrights are particular specific rights: the rights to reproduce, the rights to prepare derivative works, the rights to distribute copies, the rights to perform, the right to publicly display, the right to transmit, and some other rights too. But these are the ones that we really care about. Reproduce, copy, the right to make copies. The author has the exclusive right. There are a number of ways that the copyright ownership might transfer upon creation of the work, and work made for hire situation, for instance. But something that may be particular interest to the gaming community and to those involved in the designer community is the independent contractor doctrine, whereby an independent contractor that creates a copyrighted work while working for another entity doesn't necessarily assign the copyright in that work to that entity. We see this a lot in artists that are developing projects for a a particular product or a particular collated good. The assignment of that copyright doesn't necessarily occur unless it is a work made for art or unless that's contracted out. Copyright does last for a limited amount of time, but I think, as everyone here is probably familiar with the controversy, it is a long time. Life plus 70. You're not going to run out of that copyright anytime soon. Okay, check this out. I'm so excited for this. I am an attorney, and I get a lot of vampire jokes. So I right now am going to create Ethan the vampire. Oh, look at this. That's right, folks. Boom, boom. He's got fangs, and we're going to give him a nice little color. Okay. All right. There he is. Ethan the vampire. I have just independently created a work of authorship, and I'm going to save this bad boy, and I'm going to fix that in the tangible medium expression. Copyright is now mine. Real-time copyright creation. I love this work. Isn't this a great work? How would I go about protecting this work? Well, I have copyright right now, but one thing I could do is I could file registration with the United States Copyright Office. These are incredibly inexpensive to do, under $100. It varies a little bit based on the type of work that you're doing. But it sets a publication date, a registration date. Here's a recent Wizards of the Coast copyright that I pulled off of the United States Copyright Office's register. You can find this all online. It shows the date of publication, the date of creation. The important thing to do when you're, why you need to register a copyright is because in order to bring an action for copyright infringement, the copyright owner has to actually own a valid copyright registration. Now, this is changing somewhat in the coming months based on the Copyright Office's Copyright Claims Board, based on recent legislation. We'll see what happens with that. But right now, the Supreme Court has said if you want to, if a copyright owner wants to file an action for infringement, then they got to have a copyright registration in hand. How do you prove that the copyright has been violated and damages are owed? Well, the plaintiff shows it owns a valid copyright and that the defendant copied. The defendant had access to that work, and there's a substantial similarity in protectable elements. That's it. That's it. And that is those are all of our rights: our reproduction right, our distribution right, our right to create derivative works. You all are now already kind of anticipating me moving into virtual tabletop and streaming. I'm certain. But each of these rights, if these rights have been violated, then there are potential remedies. If there is a prompt registration under the Copyright Act, in other words, if that copyright was published and created and then was promptly registered with the United States Copyright Office, then the plaintiff can get attorney's fees and statutory damages. And as as I mentioned before, this is can be a little bit of, we're going to pause here for just a moment because I got a message. Oh man, are we still on protecting a trademark? I sure hope not.
We are.
We are?
Yeah.
Man, did we miss all these slides? James, you got to jump in and help me.
I tried to tell you we can't.
I tried, but I can't give you access to my computer, James. Come on.
Oh yeah, I'm talking to a lawyer. I keep forgetting.
Think about it. So if we've still been on protecting a trademark for all this time, with just
go ahead and hit current slide on the top there, and then you should be able to get back on track.
Oh my gosh, can you believe I did this? I'm looking at it over here.
All right, I see. You're sharing the wrong screen. That's what it is.
Oh man. All right. You know what? We're just going to go audio here. All right. Okay. Let's go audio. I've had some, listen, there were some really good pictures in there. I even drew a vampire and got copyright in it, on screen live. But let's talk a little bit about the copyright and our derivative works. And let me get out of this so I can just actually talk to you all. I'm happy to, how long ago, James, how long ago was I on protecting a trademark?
I think you got about 4 slides deep.
Yeah, man, that was brutal.
Yeah, sorry about that.
That was super brutal. And you were trying to control my screen too. Yeah, I can't even exit out. Folks, discard. Folks, we're gonna talk a little bit about the copyrights right now, because this is important. This is bringing the whole reason why some people want to probably watch this is because we want to talk about virtual tabletops and streaming. So I am going to actually skip ahead a little bit, and we're going to go right here, and I'm going to show you some stuff that really just, it's gonna. Is that right there? I was the entire time I was on the wrong screen. Now I'm on the right screen. Okay. So, James, see, look, it's working. All I needed was you.
Success.
Yeah. Okay. Tangible form. So let's just focus on what is a copyright, because we need to have this understanding of these particular rights. Copyright is exclusive right to reproduce, prepare derivative works, distribute copies, perform, display, and transmit. All right. And I think I mentioned earlier that independent contractors do not automatically assign these rights to the folks that they're working for. So simply because you have an independent contract relationship with someone that's producing a work does not mean that independent contractor's copyrights in those works, be it artistry or even software code, are automatically assigned to the one that's publishing the eventual work. In order to show infringement, there's registration. Attorneys are expensive. Prompt registration is recommended. But let's talk about how there is an authorized use. We're a half hour in. We only got a half hour left, and this is the part that's kind of meat. Is if there are if a particular entity owns copyrights and a particular entity owns trademarks, then how in the world am I, the gamer, supposed to use these copyrighted works in my games? And there are a couple simple, obvious answers to that. One is known as the first sale doctrine. When I purchase a book, then that copy of that book is mine, and I can kind of, do what I want. I can rip it up. I can draw on it. Just because I draw on that book doesn't mean I'm creating a derivative work of that particular book, that particular copy of the book that I purchased. However, photocopying or making copies, even if for personal use, could be deemed a violation of the reproduction right of a copyright. So you've probably seen this phrase right up here that I put by anonymous lawyer. James, please tell me that slide is actually showing. Yes. Are you still with me, James? I'm going to pretend that it is. Permission is granted, and read it just in case. Permission is granted to reproduce this page for personal use. How often have you all seen that? That's a license. That is the copyright owner stating that you can make a copy of this page, But there are certain limits on that license, and we're going to see these limits throughout in your terms of use and throughout any sort of these authorized uses that are showing in these licenses. Is what's the scope of the license? How long does the license last? What can the licensee do with it? And in particular, when it comes to licensing of trademarks or licensing of copyrights, you're going to see some particularities. Specifically, when it comes to a trademark, remember we talked about goodwill and we talked about quality control. We talked about that cease and desist letter and how the trademark owner needs to enforce its rights and its mark in order to maintain that distinctiveness and therefore the trademark rights. So because of that, a license of a trademark will be accompanied with some sort of assurances that the goodwill associated with that trademark is going to inure to the trademark owner, and that there's going to be some sort of quality control so that consumers, the ultimate protectees of trademark law, are not put at risk, that quality of those goods and services is going to stay the same. In terms of a license of a copyright, as we mentioned, there are several different copyrights: the reproduction right, the distribution right, the derivative work right. And we're going to see in these licenses how those rights are treated. In this case, permission is granted to reproduce this page for personal use. Here's the reproduction right. It's being licensed to impliedly the owner of that page, or at least the holder of that page, for a personal use. So I can reproduce it so long as I'm using it personally. I think we might interpret that as being not commercially. When we move into virtual tabletops, we'll see that those licenses are treated through our terms of use agreements. Now, this is the exciting part. Okay, I know we've gone through a half hour of boring lawyer stuff, technical problems where I stayed on a USPTO slide and didn't move forward, attempts to actually show you my elaborate hand motions and then to draw a vampire. But now we're actually going to get into gamer fun. I was listening to Jeremy Crawford yesterday on the Ask the Sage transmission that OrcaCon did, and it was awesome. And he said, you'll see these combos that occur, and a lot. I'm speaking. This isn't verbatim. All right, I'm paraphrasing the Sage. But he said you'll see these combos that occur, and that's purposeful. And we're trying to figure out how this can stack on top of this in order to create this result, and then let you gamers, you lovers of the IP out there, figure it out. That's what happens in these terms of use and these terms of service as well. Well, you all don't like to read them. I know no one likes to read a terms of use, terms of service. It's got a bunch of gobbledygook in it. There's stuff up here, there's stuff up down there. There's long, multisyllabic words. There's defined terms. But here is a challenge: is to see how these combos, how you can create term combos and how they stack up. I'm going to show you a standard. This is kind of a typical term combo that you'll see in software licenses, software as a service licenses, virtual tabletops. Probably, are probably not going to be different. Again, I'm not giving any specific advice or analyzing any particular scenario. But let's look at this combo. We're going to see a representation of authorization concerning content uploaded. It might look something like user represents that the content it uploads is owned, or it has owned by user, or user has rights to upload it. Something like that. We're going to see somewhere else then a warranty against infringement. It's going to look something like user warrants that any content it uploads will not infringe the rights of any third party. Something like that. Then somewhere else there's going to be an indemnification that doesn't look like it's related. It'll say that user hereby indemnifies and holds harmless software owner because from any cause of action arising out of or related to, its participation in this agreement. Something like that. Those are generic statements. I don't think anybody has those verbatim. I don't know or not. I pulled those off the top of my head, but that is a term of use combo. We have a representation of ownership, a warranty against infringement, and then a corresponding indemnification. So what does that mean? That means that if a user uploads content that violates the warranty or that the user isn't authorized to use, then that could be deemed a breach and trigger the indemnification provision. So if the owner of particular content were to sue the software or software as a service provider that provided these terms of use, that software or software as a service provider might be able to seek indemnification from the underlying user. That's the combo right there. It's a reason why these terms of use should be read. It's a reason why these terms of use and terms of service should be carefully crafted. And it's a reason why everyone should read it and understand what rights are being given up and what duties are being required and what performance is necessary. There's the kicker add-on that probably people have thought about. Everyone should read is an assignment or license of a user's rights when they sign that click wrap or that shrink wrap or the terms of service, the terms of use agreement, and see what's happening with stuff I create on that platform. From a platform side, in trying to figure out what's happening with stuff our users create on our platform. Who gets to own those rights? Who gets to use those rights? What rights are they? And how should they be distributed? And we can go back to our licenses. Can't believe I was working off the wrong thing. Our licenses kind of determination. What's the payment? What's the manner? What's the content? What's the duration of use? When we stream, we're going to encounter these rights as well. The kind of an industry standard right now are fan content licenses. I put an example of Wizards of the Coast, a link to it up there. I'm not going to be analyzing that fan content license or discussing its content at all or how it might affect any particular use. But we are seeing that in the industry, I think there are a couple. Pinnacle, I think, also has a fan content license that's freely available. This is kind of starting to become an industry standard because I think, and businesses know that their content should be streamed. People love their content. People love using it. But how do you get around the copyrights? How do you get around allowing people to use your content safely and understanding that they are actually authorized users? This can combine when you've got a virtual tabletop and then that virtual tabletop is then being streamed. Look at those stacking terms. There's a game that has, the game itself is going to have particular rights. And then that game itself is going to provide licenses for those particular rights and all those integrated mechanics, artwork, and content that's involved in the game and how those rights have been distributed to the game and then to a user of the game. Then a party takes that game and puts it onto a virtual tabletop. That virtual tabletop also has terms of use and licenses concerning its rights, including its software code and any sort of artwork or content, expressive works, even trademarks that are occurring on that virtual tabletop. And then you're taking the virtual tabletop and putting it into a streaming platform. And that streaming platform itself is probably going to have a discussion of rights, those integrated mechanics, its artwork, its content. And so we're going to have to find a way to stack all this up so that the use of the streamer is licensed out to the people. That's why we got to read these terms of use, these terms of service, and the fan content licenses. Of course, different rights are going to be treated differently. There's no duty to enforce a copyright. The copyright owner gets to determine whether that copyright should be enforced or not. It's not like they're going to lose their rights because they don't enforce it. They may lose their market share. There may become less value, but it's not like the right itself is going to go away. That's different from a trademark because remember, a trademark's lack of enforcement, or it's just willy-nilly licensing to anybody without any sort of association of goodwill or an idea of how to keep that quality control in check, can actually lose rights, which is why you may see a different treatment in licenses moving from the game into the virtual tabletop to the streaming platform of how trademarks are used. Finally, I wanted to take a moment to discuss that common misconception, that common idea that I'm using it personally, so therefore it's okay. It's fair use. There is, hang on, got to share this stream again. Bam, look at that. See, all I needed was a little more practice on this, James, and I would have been solid. Next time, right? Well, hopefully we'll do it in person next time. Fair use does incorporate an idea of what is the purpose and character of the use. Is it nonprofit? Is it not commercial? Is it just for educational purposes? When courts determine whether a a copyrighted work or trademark work, but we'll focus right now on copyright works, whether a copyright work was fairly used, and whether, even though it was used in violation of rights, the First Amendment protects from an infringement action. They look at four different factors: the purpose and character of the actual use, the nature of the underlying work, the amount and substantiality of the work that was taken, and then the effect on the market. There is something to be said for entirely non-commercial use that has no effect on the market, maybe is political in nature, somehow embraces a First Amendment, the heart of the First Amendment. That's the case, generally courts are probably going to fall on the side of fair use and say that this use is perfectly is not actionable, that the court cannot enforce copyright against a party using the work in that manner. But that's not the only thing it looks at. And certainly for-profit works can actually be deemed to be fair use as well. It's a factors test that uses lawyer math in determining what weighs on whose side and how those rights should actually be enforced or not. So I'll just say it. If you take a copyrighted work and you make a copy of it, and that copy is only for personal use and is not commercial, it doesn't necessarily mean that you haven't violated the copyright of the copyright owner. That sounds fairly specific, but I gotta not necessarily. There are a number of factors that are involved. In trademark fair use, can also, that's also a thing. There's nominative use. If I want to describe a particular product and I'm going to use that product's trademark, I can do it under a few particular guidelines. I can't use any more than necessary. It's also not a defense that's recognized universally, but it makes sense. There's descriptive use. If there's a trademark that's just descriptive of an underlying good, and I happen to use that to describe some kind of good, and I'm not using it as a trademark, that's a fair use. And finally, there is the Rogers test, which is a long and drawn out conversation that I love to have concerning use of a trademark work in an expressive work, and whether it is related to the underlying expression and whether it explicitly misleads consumers or not. These are kind of our ways out, but our ways to exercise our First Amendment rights and still recognize copyright and trademark rights. But as a rule, I just want to focus. Everyone should keep looking at those licenses, at those terms of use, and trying to understand what they actually mean. This is how streamers, virtual tabletop players, and gamers, whether they be developers, artists, or just players, can really start to understand rights and start to work with them in the virtual tabletop and streaming environment, in the online environment, to ensure that they understand the rights afforded and how to infringe them. And let's see here if I've got any. We're at 12:13. I'm supposed to be finishing here in what, about 12 minutes? Is that right, James? Do I have time for some questions or no? You still with me, man?
Oops, sorry, I was muted.
That's cool.
You do have time for questions.
All right.
Yeah.
Okay, so I'll take any questions. Once again, I want to reiterate that I'm not providing any general legal advice, but I love to talk about this kind of stuff. And I don't know where I'm going to see these questions, though. Is it going to be in the group chat? No, those are questions from you.
The stream chat, but I'll go ahead and curate them for you.
Oh, okay, cool. Thank you. Maybe I can. Boy, I'm sorry about my technical snafu there. I heard some discussion of issues related to technical problems in an online, but who would have thought I would have problems with a Zoom PowerPoint presentation? Too many screens, man. Too many screens.
Odd Socks, thanks you for sharing your knowledge with them.
Oh, well, that's not much of a question, but I'm sure happy to do that. Yeah, cool. It's good knowledge. It's not like it's secret knowledge, everyone should just try to understand these rights exist. And if you do have a particular license question, then go see a lawyer. But if you don't, then just read those terms of use and terms of service. Look for stacking. That's something I think we see these rules lawyers in my games at least do a lot, is they try and figure out how to get the most damage or how to get that special sneak attack. And that can be fun. So then when they skim over a term of use or a term of service, it doesn't make much sense to me, because don't you want to see how your actual rights are being affected? You probably do.
We actually do have a question from our executive director.
Oh, okay.
So one of the things that comes up a lot in my job is people not understanding why, let's say, a print company won't print out a rule book or such. Can you expand on that for them, for people?
Why a what company?
Let me go ahead and highlight this for you so you can actually see it. Apologies.
Actually, I don't even know where you're looking right now, but
there you
go. A print company won't print out a rule book. Well, I'm not sure what a print company is. This may be a company that prints on demand or prints particular services. I can, how about this? I'll answer this generally. The reproduction right of a copyright is an exclusive right of the copyright owner. And any party that violates that reproduction right could be found to be liable. There are a number of cases interpreting who controls that reproduction, especially when you get into kind of DMCA takedown discussions. But in terms of simple print books, it's pretty clear who is actually making the reproduction. And when a party makes a reproduction, they could be deemed to be violating that reproduction right. So they're going down to your local Photoshop and then trying to run a few copies of copyrighted work is something that I think is generally unadvisable, because the allocation of liability may not simply be on that party that's running the copies. Does that kind of answer the question without getting into any particular specifics about who might be liable or what print company that might exist? It's a good idea to get permission. It's not that hard. If you, I run a game where I use a third-party source book, and they had some really cool art, and I wanted to use one of those pieces of art as a token in my virtual tabletop. And so I asked that third party if they could provide me with a token and a license to use this particular art that was in their book in the virtual tabletop. And it was a conversation. I'm not going to, say how it came out or, what happened, but it was a good conversation. And that's certainly, something that people should be aware. You're not restricted from approaching a copyright owner to seek a license. License doesn't have to be something, really fancy. Let's see here. It looks like another question as I lean in and you get a real good close up of my nostrils. Yeah. Sometimes people are mad when independent businesses won't make copies of copyrighted work. I don't think I need to make a legal opinion on just making that observation. Yes, sometimes people get mad when independent companies will not copy people's copyrighted works. Cool. Any other questions?
I got one.
Sure, James.
You've touched upon it in the talk. Can you give some more examples or basic post scenarios once you do receive a cease and desist, whether it's valid or not?
Man, cease and desists are so hard because, the lawyer knows that the lawyer's being the bad guy. And oftentimes these are friends. These are fans of a particular IP. Sometimes they're not. And sometimes there's willful infringement, or there's someone attempting to capitalize off of a particular goodwill or particular stance. So researching and understanding how to issue those cease and desists are really important. It's an integral part of the enforcement regime, and it doesn't have to be issued by an attorney. However, there are laws in place in some states and some jurisdictions that restrict the and accusations of infringement. This is to kind of keep a rein in on copyright trolls or patent trolls, folks that might just want to try and make money off of scaring people rather than actually exercising a valid right. So upon receipt of a cease and desist, it can be a little bit scary too, but usually the cease and desist format is going to have a particular demand in it. And that particular demand is usually going to say, contact us by a date. And that's encouraged. Lawyers cost a lot of money, and litigation costs a lot of money. It costs a lot of time. There's an opportunity cost associated. There are a number of costs associated with actually enforcing right through a cease and desist or through infringement proceedings. And sometimes it's just better just to try and get it taken care of outside of court. Don't get too scared when you get that cease and desist. It's not the end of the world, unless of course it may be because you're a willful infringer and the other party really wants to make an example. But oftentimes, especially in cases of trademark infringement, it's an entity just needs to safeguard its mark and the goodwill associated therein. Did that answer your question?
Yes, that did. Thank you.
Cool.
And if folks have questions, please put them in the stream chat, and I'll go ahead and curate those for Ethan. To kind of follow up on the statement you made, I've been in a situation where I've had to write a cease and desist. What other examples legally could you do before getting to the step of hiring a lawyer? Like there might be some ignorance on like what tools you have at your disposal before you make that leap.
Well, I didn't get into the DMCA in our talk at all. And do I have now? I'm not even going to trust that PowerPoint, man. That was brutal. But there's a kind of a takedown process, and you'll see this in any major service provider or host will have a way for intellectual property right owners to dispute some sort of use of their rights that's being hosted on that service. And everyone always hears about the songs that are being played on YouTube, and having the takedown notice occur there. But any sort of hosting provider is going to have in its terms of service, read these, and a DMCA registered agent and a takedown process. This isn't necessary to have an attorney do this. As a rights owner, rights owners have, can enforce their rights. And just by going down that little checklist that's probably provided by that host and complaining of those rights, there is a way to enforce and to ensure that your rights aren't being violated by any sort of third party that's hosting. Something that's kind of important that we talk a lot about these days. It's a hot topic about what kind of liabilities and safe harbors these hosting providers have. One of the safe harbors that these hosting providers have in terms of copyright is that they are not going to be individually liable for one of their clients' posting of content to their site if certain standards are met. And one of those standards is having a good notice and takedown procedure by which property rights IP rights owners can enforce their rights. So just check that out. It's not hard to do. Just go in there and use Google to make a search to find out where these IP policies are, and figuring out what to do from there. How about that there's an alternative. You can always get a lawyer to do it too, because sometimes you do want a lawyer to do that. There's going to be a legal team that responds and that legal team may, in some cases, actually say that no, you haven't proved that you have a right, and we decide not to take it down. I've had that happen before. But for the most part, folks like to be on the safe side, and there's pretty clear cut infringement. A takedown notice isn't that difficult to achieve.
Very cool. Yeah, no, that answers a great deal. Thank you. I don't have any other questions in the stream, but I guess I got one more question that could help indie developers. And it's something I've run into certainly in the past. That is, what is the flexibility around parody or using parody in your content? Like it gets, my experience with it is it's been very nebulous, and you don't really know quite which way it's going to swing when you go, or if you get like, a cease and desist. But can you get a little more in depth on like what is the approach for that?
Well, yeah, parody isn't parody isn't in that's the enshrined First Amendment use, right? Is when I'm creating parody. If I'm creating political parody, I mean, that's it. That's why the First Amendment, was created. That is penultimate First Amendment use, is political parody. There's been a lot of recent discussion concerning copyright and parody, and whether the claim is actual or not. We can go back to Two Live Crew using Pretty Woman in a fairly lewd manner in its lyrics without permission from the Roy Orbison folks. In that case, Two Live Crew argued that it was a fair use, even though they were selling records. Roy Orbison was never going to be doing rap music, I guess. Was that part of the argument? The argument was essentially, though, that this was a parody. This was talking about how how women who make their money living off the street are to be respected, or how they're not to be respected. The argument, while I'm not sure if the court bought it so much, that case does stand for the proposition that simply because there's a commercial use doesn't mean it's not a fair use. It was the way to go, though, was the way to argue. If you can have a political parody that's making some sort of commentary, then the use is most likely to be deemed fair. We see this in recent cases where the parody has to be honest. A case just came out of the Ninth Circuit. This is something that probably a lot of the gamers are familiar with, is Oh, the Places You'll Boldly Go was a book that used Dr. Seuss's iconic artistic style, in some case iconic artistic styles, where I'll draw the line, to describe Star Trek. And there was a claim of parody that the childish, the child-focused artistic style of Seuss was in some way attempting to contrast with the sexualized adult themes of Star Trek. And the court didn't buy it, but I guess the real thing, if it's a parody and it's an honest to goodness parody that maybe even has some political undertones, then there's a good chance that it's going to be protected by the fair use doctrine. But that's the kind of thing that a lawyer really should look at.
Yeah, like in my particular example, I think I could talk about it because the company no longer exists and it's really old. But it was a music game or trivia game, and we had a caricature of like someone with a Devo hat, because it was an 80s category. For those of you who don't know who Devo is, it had the atypical hat, and they had the whip. And like when the question came up, they did the little whip snap, and we were like, oh, we know we're gonna get flack for this. We did get flack for it, but all we had to do was remove the whip, and we were like, really? We can save the hat? Because that's what I think of when when I think of that music video. But
Hmm.
Yeah, you never know how it's going to really like land,
No,
basically.
you don't. And if it's a trademark cease and desist, then the idea is you just don't want to have consumers get confused, right? So long as consumers aren't confused, everybody wants to get along. It's a good marketplace. Competition is healthy, and if the goodwill of a particular good or service is maintained, then we can, everyone can hold hands and be friends. See, lawyers aren't all blood-sucking vampires. Gosh, that was a good picture. Too bad y'all didn't see it. Too bad y'all didn't see it
Yeah,
live.
if you want to share that picture, I can post it on our
You know
Discord.
what? I will give you that picture.
All
I
right,
will give you
cool.
that picture.
Look,
It was terrible. So bad.
look out for that picture on Discord after the chat.
Yeah.
But we do have actually another question in the chat uh,
Okay.
from Haley Drescher. What is the general procedure or possible problem behind copyright or trademark infringement across international lines?
Okay. Well, this is fun. Gosh, boy, that's a deep question. But copyrights are not universal. However, they are mostly universally recognized. I would encourage independent study into TRIPS, the TRIPS agreement, and into the Berne Convention, BERNE. Although I've heard some people say it Bernie, but I don't know how it's actually pronounced. The idea is that there are a number of the international community recognizes copyrights that are developed from within by individuals within the members. And so because that copyright is owned, even though things like trademark are governed based on jurisdiction, if I'm using a trademark in the United States, it doesn't mean that I have trademark rights necessarily mean that I have trademark rights in Canada. But if I have a copyright in the United States, well, that work is still is mine. And if somebody from a different jurisdiction uses that work and copies it, well, I mean, are they really engaging in an independently created piece of authorship? And the answer is probably no. Here we go. There's the lawyer in the jurisdiction where the infringement is occurring is the party to talk to, because that's the attorney that's going to be able to tell you what particular rights are available there. As an example, the personal reproduction right varies greatly across the US if it's for commercial purposes or not. I know as my example here, permission is granted to reproduce this page for personal use. Anonymous lawyer wrote that. That's a US based license for a personal reproduction. In other jurisdictions, it's different. And I'm not licensed in other jurisdictions, so I can't really talk about it, but or at least I can't. I mean, I can talk about it. Anybody can talk about it. I can't give any particular knowledge about it. So I would recommend seeking out an attorney in those jurisdictions. And if you have a local attorney, that local attorney will probably be best able to advise you who to look for in those jurisdictions. So that's what I got.
Very cool. Thank you.
Yeah. And you got them. You got them. I mean, they're there. Just if they're there. You got a copyright. It's not like, oh, someone in another country can just be like, ha ha, you're an American. I'm taking your thing. You got it.
Haley says, interesting. Thank you.
Mm-hmm.
Does anyone in the chat have any other questions for Ethan? I think we have maybe a few minutes left.
Oh, okay. No?
No. Looks like we're all
well,
good.
Listen, y'all, if you do have any follow-up questions, feel free to email me. I'm happy to answer any questions that are general. I really love this convention. I love what it stands for. I love being a gamer. And I really think a discussion of rights is important, especially as gamers. My little intro there, talking about how we move into VTT and to streaming and how this affects rights. I mean, it really does. It's a lot different than just sitting around a table and throwing down a personal copy of something you reproduced. Things are different now, and stacking up all those terms of services on top of each other so that we can enjoy our favorite streams. I know everyone's a Critical Role fan. I miss Paw Paw like the deserts miss the rain. I want my NAD pod to go back to Bohemia, but I enjoy listening to these streams a lot, and I hope people continue to make streams and aren't scared, but also understand, the rights and how they're distributed. So feel free to shoot me any questions. Love talking to you. Thanks for having me here. And I really hope next year we can do this again with a good presentation, maybe a couple other lawyers.
Awesome. Thank you so much, Ethan.
All right. Thanks, James. Talk to you later.
Take care.
Bye.